All right, I'll call this meeting to order. Will the clerk please call the roll?
Nancy Grisili.
Present.
Gordon Binkhurst.
Here.
Josh Kaplan.
Here.
Liz Gillette.
Here.
Kevin Ahern.
Here.
That is the TPZ/Inland Wetland Agency. Absent are Commissioners Lyons, Gomes, and Neville.
Neville.
Present for staff are Todd Dumais, Town Planner, Designated Wetlands Agent, Gina Verano, Deputy Corporation Counsel, and Brian Pudlick, Senior Planner. That is the roll, Mr. Chair.
Thank you, Mr. Dumais. So tonight, I think everybody knows why we're here tonight. So what we're going to do, just in order, a quick order of business. So the first thing on our agenda is actually an executive session. It's pursuant to 1-2006E of the Connecticut General Statutes regarding the discussion of an attorney-client privileged and confidential legal memorandum regarding IWWA 1203 and the Intervenor Petition. So that's going to be the first thing that we're going to vote on tonight. Whether or not we actually go into an executive session, once that's done, then when we come out, I'll just do a little explanation to everyone here what the order of things are going to be tonight. All right. But so first things first, as to the executive session, is there a motion by any member as to an executive session? Mr. Binkhurst.
I move that we enter executive session for the purposes of discussing an attorney-client privileged and confidential legal memorandum.
All right. Is there a second?
Second.
Motion and a second. So all those in favor say aye.
Aye.
Those opposed? Any abstentions? Seeing none, the motion passes, and I invite Attorney Gina Verano, Todd Dumais, and Brian Pudlick to join us. So for the public, we will return right after the executive session. All right, we are back. Thank you, everybody, for your patience. So what we just finished doing was having a discussion with our attorney over the memorandum concerning the law that applies tonight. So I'm just going to walk, as I've sort of been doing this whole time, I'm going to walk everybody through just very quickly sort of what the process is going to look like tonight. Before I get to that, though, I want to very briefly, just a few things. I'll start with the public. I can say this without a doubt. I think this has been some of the most prepared statements that I have ever witnessed, certainly in a wetlands application. There is often a lot of confusion surrounding that particular role that we have, especially when we have applications that have overlapping questions that may touch upon more than one of our roles. And everyone that came up and spoke understood what we were here for, and I am greatly appreciative of that. I'm not sure every town has that kind of input, and it was really, truly, it was wonderful to see, but more importantly, it was helpful to our deliberation. I also want to thank town staff. And I know what I have thanked you already on the record, but I want to say again, I don't think a lot of people realize just how small the Planning and Zoning Commission office is. I think 75% of it is actually in this room right now. There are 4 of you guys, right? Yeah. And they accomplished a heck of a lot. And this application was a substantial lift for this staff. And I am proud of them, but more importantly, I'm so excited I get to work with them. I cannot not thank Corporation Counsel for putting up with all of our shenanigans, our multiple questions. We really put Gina through her paces, and she was fantastic. And Dallas isn't here, but I want to thank him as well. Really, it was so important to have you involved, and we're really thankful for that. And finally, I want to thank my colleagues. This is the reason I keep doing this is I get to work with these really smart people who really know their stuff, and they're also a pleasure to work with. So just thank you, everybody. So to our role tonight, just to clarify, we are sitting as the Wetlands Agency tonight. We're not working on zoning tonight. We're not working on planning tonight. We're simply sitting as the Inland Wetlands and Watercourses Agency for the town of West Hartford, one of 169 in the state. And we're going to be looking at this through the lens of our wetlands regulations for the town of West Hartford, which are promulgated pursuant to Chapter 440 of the Connecticut General Statutes. And to be clear, just so everybody understands, that what's going to happen tonight is going to be a deliberation on one application, on the 1700 application, not the 1800 application. And then we will also be considering the Intervenor's Petition on 1700, not 1800, on 1700 tonight. So tonight, when we deliberate and vote, we will be deliberating on the substantial evidence in the record and the law concerning wetlands. We are not going to be acting when we vote in either case, in either the 22A-19 intervenor or on the wetlands. We are not going to be acting as a sort of mini EPA. So there are going to be all kinds of other environmental impacts that are not part of our consideration. We are a wetlands agency. We're not an air agency, for instance. So we'll be looking at through the lens of who we are, which is the wetlands agency for the town of West Hartford. So the order of things tonight. The first thing that we're going to do is we're going to consider the intervenor's petition. So that intervenor's petition was filed pursuant to 22A-19 of the Connecticut General Statutes. And our determination will be as follows. We're going to have to determine if the regulated activities are reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the natural resources of the state. If yes, then the Inland Wetlands Agency must make a finding as to the existence of a feasible and prudent alternative. If no, the Inland Wetlands Agency does not need to make any further findings. Once we are finished with the intervenor application, we will move on to the wetlands application. We will be looking at, as I have mentioned before, through the lens of our inland wetlands regulations. Our determination in that case is going to be whether the regulated activities may, based on substantial evidence in the record, have a significant impact on wetlands and watercourses. If yes, then the Inland Wetlands Agency must examine what feasible and prudent alternatives exist that the applicant may investigate, propose such alternatives, and deny the application. If no, then the Inland Wetlands Agency will not examine feasible and prudent alternatives and approve the application with or without conditions. So that is what we will be working on tonight. So without further ado, let's get right to the deliberation. So we're going to start with the intervener. Mr. Dumais, we'll start with you, actually.
Thank you, Mr. Chairman. This is agenda item number 2 on our agenda, and that's 1700 Asylum Avenue, Intervenor Petition, Christine Feely, Jessica Rubin, and Gary Schulman.
Thank you, Mr. Dumais. So at this point, I will entertain a motion for the purposes of discussion. Mr. Binkhorst.
With respect to the activities proposed by the applicant, I move that we find, based on the substantial evidence in the record, that we are not being asked to authorize conduct which has or which is reasonably likely to have the effect of unreasonably polluting, unreasonably impairing, or unreasonably destroying the natural resources of the state.
Is there a second?
Second.
Motion and a second. Mr. Binkhorst, do you wish to comment?
I do. So, again, as to Mr. Ahern's discussion, this was a very complicated and application that we looked at. And considering the intervener's application, I considered their petition, I considered their testimony, I considered the cross-examination of the applicant. And that is the body of evidence that we looked at when considering the intervener's application. And of course, you know, it's a pretty high bar to unreasonably pollute our environment, and being reasonably likely on top of that. We must make our finding on substantial evidence, not on conjecture, not on speculation, and not on questions or concerns raised. And again, you know, it has to be reasonably likely, which again is a high bar. In my opinion, there was nothing in the record from the intervener's presentation or the cross-examination, keeping in mind that they did not call any experts, that meets that burden. So that is the reason for my motion.
Thank you. Mr. Kaplan?
I will echo Commissioner Binkhorst's detailed and thoughtful comments.
Okay. Any other comments? Okay. Seeing none then, let me try your minds. So then all those in favor say aye. Aye.
Aye.
Those opposed? Okay, the ayes have it. Any abstentions? Okay, the ayes have it. All right. So since we've made that finding, there are no other findings required as to the petition. Next up, Mr. Dumais.
Item number 3 on the agenda, 1700 Asylum Avenue, application Inland Wetland 1203 of WEHA Development Group East, LLC, requesting approval of an inland wetland and watercourse permit to conduct certain regulated activities which may have an adverse impact on a wetland regulated area. The applicant proposes the construction of 4 multi-story residential buildings with related site amenities in addition to drainage, landscaping, parking, and associated site improvements. Work is proposed within the 150-foot upland review area and includes a direct wetland and watercourse impact. Application determined to be potentially significant on July 10th, set for public hearing on Wednesday, September 6th. The hearing was opened and immediately continued to October 2nd, continued again to October 23rd, then again to November 6th. On November 29th, the public hearing testimony began, and the hearing was continued to December 11th and again to December 13th. The public hearing testimony concluded at that hearing on December 13th. The deliberation and vote was scheduled for January 3rd and postponed to this evening, January 17th. Just as a reminder for the commission to please make sure when you're talking to press your microphones so the red light comes on so you're being recorded. Thank you.
Thank you, Mr. Dumais. So again, on this item, I will entertain a motion for the purposes of discussion.
I'll make a motion.
Mr. Binkhorst.
Based on the substantial evidence in the record, I move that the request to conduct certain regulated activities at 1700 Asylum Avenue pursuant to an inland wetlands and watercourse application, IWWA 1203, should be approved. subject to the conditions as the standards and criteria for decision as set forth in the Inland Wetlands and Watercourses regulations for the town of West Hartford in section 10.2 has been favorably met.
All right, is there a second? Do we have a second? Do we have a second on the motion?
I'll second the motion.
Thank you. Motion and a second. Mr. Benkhorst.
Again, this was a long and complicated process and application, and I considered many different things in terms of the applicant's presentation, the applicant's revisions and presentation materials, our town comments, our third-party wetland scientists that the town engaged in order to review the application. And in my opinion, I don't see where a significant impact to the wetlands and resources of the state occur pursuant to our regulations.
All right. Thank you, Mr. Benkhorst. Ms. Grisilli.
I agree with his definition of the motion.
Do you have any comment, any further comment? Sorry.
Pardon me?
Do you have any further comment? Just as the
I do.
second, you have the...
I do not.
Okay, thank you. Any other comment? Yes. Mr. Kaplan.
I also very much appreciate the applicant's detailed team that came before us and presented a very thorough case. I very much appreciate all of the efforts that they've put in with respect to wetland mitigation, enhancement, invasive species removal. But I do feel that there's a possibility that there is significant impact here. And I don't know that I can vote in a positive manner in this application. Relative to 22(1)JJ9, it states any activity which results in the destruction or impairment of an identified aquifer or recharge area, the reduction of an inland wetlands and watercourses natural flood storage capacity, which might result in increasing the volume or velocity of water, leading to upstream or downstream flooding, erosion or sedimentation, or an impairment of the natural flushing of stream sediment during normal flooding. And my concern with that is relative to the number of large diameter trees that are being taken down in the upland review area within 100 feet or less of the wetland. And it was established during the presentations by the applicant's own experts and during the cross-examination by the intervenor that those large diameter oak trees have significant carrying capacity for water and storage, and that those root systems for those trees extend far beyond the crown of those trees into the wetland. So the removal of those trees will be affecting the soils in the wetland area and removing storage capacity in that area. And I think that a modest redesign to increase the wetland buffers, as was indicated by the town consultant from SLR, would allow the preservation of many of those large diameter trees, which would then eliminate the physical characteristics of the wetland being changed by their removal.
Thank you, Mr. Kaplan. Real quick, I just have a procedural question for Mr. Dumais. Insofar as Mr. Kaplan has expressed these concerns, I assume, but I don't want to assume, I want to ask, would any of those concerns, could any of those concerns be captured by a condition, or was there not enough on the record, in your opinion, for that to be the case?
I think, Mr. Chairman, through you to Mr. Kaplan, you'd have to explore his modest redesign concept a little further to capture that in condition. That just those terms are not sufficient
Okay.
to capture in a condition.
All right. All right, so I understand that. Do we have any other comment? Mr. Bakhorst? Oh, sorry, nope. Mr. Bakhorst?
I do appreciate Mr. Kaplan's comments. You know, certainly this is a large development, but I just would like to point out that the impervious area was reduced from what's currently there. And these are things that are all considered when we talk about significant impacts to the wetlands. The proposed treatment of stormwater, where there currently is none. The stormwater calculations that is in the record that shows that there is an actual decrease at design points in the system associated with the development. The use of pervious pavement and a small rain garden. The installation of the buffers, upgrading of the wetlands. Movement of the maintenance shed, preservation of the champion oak, and finally a conservation easement. So while I do concur that it is in the record that mature trees do soak up more water than many small trees, I think over time they'll obviously grow, and I think that the other elements in the design supersede that. Thank you.
Mr. Kaplan?
It was also in the record that those small trees would take decades to reach 20 inches in breast height diameter. The mature oaks in particular that draw more volume of water that I'm referring to, which there's only about half a dozen, I counted them, that are within 100 feet or less than 100 feet of the upland review area that I'm referring to, are all 30 or larger than 40 inches diameter in breast height, which would take many decades for those trees to be replaced.
Thank you, Mr. Kaplan. Yes, Ms. Gillette?
The trees that you're referring to in that narrow strip was there, I don't recall, was there any reason why they were being cut down? Or was it just clear the decks?
A few of them are in the corner of one of the proposed buildings. One of them is near the Champion White Oak, and but is in the location where they're proposing to put a stormwater detention basin, which I'm also curious if that excavation for the stormwater detention basin would actually impact the root system of the Champion White Oak, though that's a little bit of a sidebar comment. Then there are a couple of trees that it's a little bit unclear from the tree inventory and the tree removal plan, but it appears on the southern end of the site, it appears there are a couple of large diameter oak trees down there that, based on the newest plans, I'm not sure if the tree removal plan is current with the reduction in parking on the baseball field or not. Mm-hmm. So I'm not sure if the couple of large diameter trees down there may end up getting preserved by that reduction in parking. That's not clear to me, but on the latest tree removal plan, it appears that they are being removed. And those are all also in close proximity, almost on top of the wetland in that area. They're very close.
Mr. Bakhorst?
I did request that the applicant provide in their inventory which trees are being removed and why, which they failed to do. They did indicate that they sought to preserve all, trees in good condition, and some of them are, frankly, just not in good condition. That's why they're coming down, even if they're in the middle of nowhere.
Agreed.
But so that element I agree is missing, and maybe we can add that as a condition of approval, that they re-examine their tree removal to try to preserve any trees in reasonably good condition.
But without a modest redesign, without some kind of redesign to the plans that we've been given, in several of those cases, that's not possible.
Understood.
Any further comment? Yes, Ms. Gillette.
I have it, it's more of a question and want to hear feedback on. 10.2 of the regulations that we are to consider talks about in section D, irretrievable and irreversible loss of wetlands or watercourse resources which would be caused by the proposed regulated activity, including the extent to which such activity would foreclose a future ability to protect, enhance, and restore such resources. And you go down to 2, and it says maintain or enhance environmental quality. And 3 says, in the following order of priority, restore, enhance, and create productive wetland and watercourse resources. So I think what my question is trying to understand our point of beginning in effect. Is what we're saying, what this says is that the proposed application before us does not hinder the ability to restore, enhance, and create productive wetland resources?
So let me just put the question of Mr. Dumaine, and without commenting on the current application, could you perhaps bring some clarity?
Sure. Thank you, Mr. Chairman, through you to Commissioner Gillette. If you look at that section 10.2D that you're reading, we're talking about the irreversible and irretrievable loss of the wetland and watercourse resource. So in the context of your question, you're going to look at an application, any application, its proposal, and their impact to the wetland and watercourse resource.
As it exists today.
As it's any impact caused by a proposed application or regulated activity. So if there's an impact or an activity being proposed in a wetland or watercourse resource, then you apply those standards.
Okay, I guess but the starting point is the wetland resource as it exists today.
Correct.
So it's not to what it was 50 years ago. It is the starting point of comparison is
Correct.
to today. Okay. And will tomorrow have I got it. Thank you.
Thank you, Mr. Dumaine. Thank you, Ms. Gillette. Any other questions or comments? Mr. Bakhorst.
Just one other to acknowledge that the significant impact to the wetland of the proposed project does include the replacement of the stormwater outfall, right? That is a direct impact to the wetland. And again, I don't see any alternatives to doing it, and it appears necessary, despite the project, that it should be replaced. And in light of all the other benefits, I really don't consider it significant, but I thought it did bear mentioning for the record.
Thank you. Yes, Mr. Kaplan.
I do concur with that piece of it, Commissioner Binkhorst. But given the large volume of material, the numbers of redesigns to the plan in a short period of time, I feel that a modification of the plans could likely be made for those trees that are probably all 100 years old plus to be preserved, which would likely reduce high volume water from increasing in the wetland as a result of removing that storage capacity for the next probably several decades.
I'd like to, so I didn't want to go too far down the road until we had a chance to discuss other items, but I do think we should go back to when I asked the question to Mr. Dumais in terms of whether or not your recommendation could be carried by a condition or not. And Mr. Dumais, could you just repeat what you had mentioned in terms of understanding or being able to answer the question, right, what we would need to answer the question?
So I think the way I understood Mr. Kaplan's request for a potential modest redesign, we would have to compare and contrast the proposed tree removal plan, in particular the trees that were identified by Mr. Kaplan in the areas within, I think I heard a general 100-foot of the regulated resource, which is the wetland in these instances, and then figure out a way, if there's a way to preserve those. Obviously, there's, Mr. Kaplan correctly pointed out a direct conflict with building locations, but in other areas, some of the trees are to be maintained as buffer areas. You know, there's some areas where there isn't a conflict with the proposed improvement per se. There might be some grading that could be reworked, but we'd have to go through and look at those or figure out a way to capture that if that was going to be made a condition, to look to explore those.
Right, but we would always then have to ask the question: does the record support our ability to issue that condition? Right, or maybe I'm wrong. Right, we couldn't say, well, you know, we want you to put a White Castle on the site as a condition of approval, right? The record doesn't support that there was any acquiescence to a White Castle being on the site. Sorry, it's an absurd example, but just to give you an extreme example of sort of what I'm sort of digging at is, as I understand, our ability to render conditions is limited in a certain sense.
It should be limited in a certain sense to issues that were identified during the hearing,
Right.
Or that are standard, that are required, or could be reasonably inferred to be required by application of an approval under your wetland regulations, or something that you had raised during the hearing in discussion with the applicant, and they may or may not have consented to. There were a couple items that were discussed that were non-standard conditions. Not a White Castle, but the movement, I think Mr. Kaplan, you suggested the movement of the proposed maintenance garage away to a location on the site more distant from the regulated resource. But yes, it should be based on the record and the testimony provided by what's in the record.
All right. So I guess let me just then get sort of narrow down to my question. Is it a worthwhile exercise to explore what Mr. Kaplan is suggesting, or will the record, in your opinion, again, I'm putting a lot on your shoulders, Todd, so if you can't answer that question, don't worry about it. But in terms of if Mr. Kaplan were prepared to make that recommendation, would it even be a worthwhile exercise given the record?
I think you individually need to go back to the record and
Yeah.
you know, look at what testimony was provided and by what expert, and then go back to the particular clause, which is in our definitions that Mr. Kaplan very quickly referenced the section 2.1 JJ9. He did it very quick, which is the last standard for the definition of significant impact. And that, again, I'll read it. It says, any activity which results in the destruction or impairment of an identified aquifer or recharge area. This is not an identified aquifer area. The reduction of inland wetland or watercourse natural flood storage capacity. We do have evidence in the record that there is no reduction in the natural flood storage capacity. That was a memo from the Director of Community Development. He's Dwayne Martin, town engineer, also the floodplain manager, who reviewed this application in accordance with our flood management standards, special flood hazard area zoning regulations, and found there is no diminishment in the flood storage capacity in the context of that review. Relied on the flood storage information provided in the application, and also compensatory storage analysis and an equal conveyance. So that deals with the volumes, resulting volumes both up and downstream. That's the equal conveyance component. And That's in the record, that this is consistent with that zoning. That's a memo back to the agency for your consideration as part of the record.
All right. So it may then, oh, well, Mr. Kaplan,
So-
you jump in before I say anything.
Then the last piece before Mr. Kaplan jumps in is the erosion sediment and impairment. So here we have, a plan that was designed in accordance with the 2002 erosion sediment control design guidelines. Again, the testimony and the evidence in the record supports that it was designed in accordance with that standard.
Mr. Kaplan.
So, Mr. Chairman, I guess I have a question then, through you to Mr. DeMay. Do the recommendations by Dwayne Martin take into account the removal of large diameter vegetation, large trees? Is that even considered, or are those calculations strictly based on engineering practices and from the civil plans with respect to stormwater detention systems?
Not exactly. So they're based on engineering calculations. They do not take into account groundwater. Really what you're talking about is the flood storage or the groundwater capacity. The compensatory storage or the special flood hazard area regulations in the zoning regulations deal with the volume, so the cuts and fills being proposed in the FEMA identified floodplain areas. So in this instance, we're talking about areas identified as a special flood hazard area or 100-year flood zone. So all of those areas, if you go in the plans and you look, we actually had them at each flood elevation demonstrate that there's no net reduction in the flood storage capacity at those intervals. So that's what this, in my opinion, as designated agent is discussing when it talks about the natural flood storage capacity. It's that capacity. Think of it as a bathtub. If you fill the bathtub with fill or take it away, it's adjusting the volume of the care capacity. It does not look at groundwater.
Or the ability for vegetation in groundwater, sponges to soak up groundwater effectively. I mean, that's what we're talking about.
Okay. Thank you. Any other comments or questions? All right, so,
Liz?
oh, Liz, sorry. Thank you.
I want to say this, just personally, for the record, this has been very difficult to keep inland wetlands separate from use. There's an obvious overlap. And we usually hear these together as a package. And there are very good reasons to not do so in this case. And I have woken up in the middle of the night and written down things like, do the sediment detention basins filter out the oil? And called Todd the next morning or gone back and looked it up and to get an answer. I really have tried to find those significant impacts on the wetlands and watercourse. And try as I might, they really just aren't there. Fixing the outflow, to me, is something that, frankly, we permit, encourage, and require in a number of our wetland areas, like Spice Bush Swamp and over at Beachland Park. This is good maintenance. Because that stupid parking lot has been there forever and ever, we can't really look at the wetlands properties that would be there if it hadn't been paved. But it was. And the state did that all on its own without permission. That was not something that came through the town 30 years ago. So I will support this application. But it is in effect, it is with a heavy heart, because if nothing else, I just think of what else it could have been, like Spice Bush Swamp East. But that's not what's being proposed, and that is not within the regulations. And I think they have frankly met the burden and have worked with the town quite cooperatively on increasing buffers and other areas. So I just wanted my reasoning to be on the record.
Thank you, Ms. Gillette. Do any other comment? Yes, Ms. Grisilli.
I'm in agreement with Commissioner Gillette, and I'm going to approve this. I attended every meeting. I read every document that was given to me. I walked the grounds twice. Once in the day about 6 weeks ago with pouring rain, just to see what would happen in a torrential rain. This process has taken 7 months. Everything the town asked for them to do and modify and change, it appears that they did that. I don't see any reason at this point not to support, and I'm only supporting the wetlands. I think we should go forward with it.
Thank you, Ms. Grisilli. Any other comments before we vote? I will very briefly say that I've been on the commission for a while, and when it comes to wetlands applications, I think we've all, at least some of us, have done this together, where I have voted no on wetland applications in which I liked the project, and I have voted yes on wetland applications in which I didn't like the project. My vote on the wetlands application is not a reflection of how I might vote in the future when wearing a different hat. And I think I've said on the record a number of times, we are prescribed in a particular way to consider the record up against the law that we have to interpret here. So in that case, and considering the record, and I actually greatly appreciate Commissioner Kaplan's comments, and I think that does present some evidence that it could be possibly significant, but I don't think it presents substantial evidence, and that's the standard that I need to follow in this particular case. So I will be voting yes on this item. Any other comment before I try your minds? Okay, let me try your minds.
hang on.
Yes, sir.
Mr. Chairman, before you do that, I did hear Mr. Binkhorst reference a set of conditions. I think it's worthwhile to discuss potential conditions. I referenced them in one of my questions I have prepared. Those, if I could ask Corporation Counsel to pass those down. So when there's a motion to approve any wetland application or wetland permit, we have a standard set of conditions. The way I've organized these, just to help you review them, is color coding. So if you're colorblind, I apologize, but I'll do my best to point those out when we get there. These are 15 conditions. Anything in black text is a standard condition that you see on just about every wetland application. The first condition referenced here is the plans of record are incorporated by reference in this permit and fully set forth herein and modified by the conditions below. Second condition is the wetland permit is subject to full compliance with the town erosion sediment requirements and shall be installed and maintained as depicted on the plans and in accordance with the 2002 Connecticut Soil Erosion Control Guidelines as amended, which they just were. The next two conditions are in blue. Those are standard conditions, but you don't always see them. You see them when there's an application that proposes a significant amount of activity, usually in an upland review area, and there's a lot of site disturbance. And that's usually when we see these applications, or in an instance where there is a direct wetland impact and we're looking at wetland mitigation or enhancement plantings, we see these. And these two conditions go together. It says the applicant shall file a performance bond or other form of surety in the amount of the estimated cost of the project's environmental controls. And then we're referring to soil and erosion controls, site drainage, wetland mitigation plan prior to the commencement of any site work to ensure the completion of the project as proposed in the inland wetland official record documents, drawings, and exhibits. Performance bond shall remain in full force and effect until all improvements are completed. You know, an example of these, just by way of reference for the commission, agency, and anyone listening, there's two of these conditions in place for the project at One Park, which was a zoning approval with a corresponding inland wetland approval, and then still over at Gled Hill, there's a performance bond making sure that your approvals come to full force and effect. The related condition here is before filing a bond with the agency, as provided above, the applicant shall submit to the town planner for review and approval in consultation with the town engineer a cost estimate for all those required improvements to be covered by said bond, prepared by a professional engineer, wetland scientist. This is something that we do. We review that for cost unit basis established by the town engineer. The next suggested condition, this is a standard condition, that the applicant shall retain a professional engineer to inspect or oversee construction and installation of the soil and erosion control measures. Inspections shall occur bi-weekly and after a significant rainfall event. There was an actual specified rainfall event. If you look at the erosion control notes on the application plans, they call out an actual rainfall event in the plan. So I left it somewhat generic here. And those reports get submitted to the planning office. Additional soil and sediment erosion control measures shall be implemented or stalled throughout the course of construction if it's determined necessary to correct any actions. Number 6, prior to the start of any site disturbance, all sediment erosion controls and tree protection shall be installed. Once installed, but before commencement of any site disturbance, including tree removal, the town planner shall be notified and provided the opportunity to inspect. That's a standard condition where my office will go out, usually in consultation with the zoning enforcement staff and also the town engineering staff as necessary. 7, all disturbed areas shall be limited to the minimum necessary to complete each phase of activity. 8, this is something that was offered by the applicant at the last meeting. So on the public hearing at December 13th, you were provided with a permanent conservation easement area. So this condition says a permanent conservation easement area shall be provided consistent with that plan with the extents shown on that conservation easement exhibit, which is in your plan materials and part of the record. Upon completion of the site work, the boundary area of the easement should at all times be plainly marked by permanent signs or an equivalent marking designating the areas as conservation area. All plantings, species, types, and quantities in said conservation area shall be maintained in accordance with the plan. A suitable reference to the conservation easement area shall appear on the deed. And finally, the conservation easement area shall be approved by the Office of Corporation Counsel before it's recorded on the land records. The next 3 conditions, in part, are unique to this project, and they came up during your discussion and deliberation with the applicant. The first one is the maintenance garage shall be moved from its current location, which was on the middle eastern portion of the parking area, all the way to the east towards the University of St. Joseph. That shall be moved to the proximate to the proposed garages on the northern end on the northwestern portion of the site. That was the area that was identified. I think, Mr. Kaplan, you identified there's a nice pocket of non-upland review area which removes it further from the wetland resource. The concern there was, if I recall your testimony correctly, your questioning, Mr. Kaplan, was there was the potential for, since it's a maintenance garage, even minor spills of any kind of petrochemical or any other equipment, fertilizers that was accidentally, taken out of the garage. The next condition, this actually goes back to something that you raised, Mr. Kaplan, the southernmost underground stormwater detention system. Sorry, that's a mouthful, but that's what that particular stormwater system is called on the plans. That shall be moved further west to avoid potential conflicts with the root zone system of the Champion Red Oak. So I heard that. The applicant said that they would explore that, and that's why I've included it here. Again, non-standard condition, but it was raised and discussed, and the applicant consented to that during the hearing. The next one is a bit of a hybrid. So it's a hybrid of a standard condition that's unique to this parcel. So in this instance, I'm suggesting that the applicant retain a professional soil scientist or wetland scientist to oversee and review all wetland mitigation, creation, and enhancement plan as outlined in the plans in the wetland assessment report prepared by All Points Technology. This next part is something that was discussed and agreed to by the applicant. That plan should also include the invasive species removal and monitoring for the forested area between St. Joseph's Brooks and the ball fields. There was a little area that wasn't directly included. Again, Mr. Kaplan, I think you identified, and they said, yes, they would look at that because it was pointed out, if you don't do that and invasives established there, they're just going to kind of outcompete and press into the areas subject to the mitigation. That soil scientist shall provide yearly reports to the town planner as outlined in the mitigation plan. There was a time frame that took the plan way out into the future. And at that report at minimum, and there's more detail in the plan, but shall provide for an assessment of invasive species removal, the wetland creation and enhancement plantings, and identify any corrective actions required. And then the last three, these are all standard. 12, comprehensive as-built certification from relevant professionals submitted to the town planner, completion of all work. Such survey and certification shall demonstrate the work was completed in a manner consistent with the approved plan. So these also include things like final as-built survey, and that will help us determine whether or not the work in the special flood hazard area zone and the grading was done per the approved plan. So they have to provide an actual certification and a corresponding A2, T2 survey to verify that. 13, the engineering or planning divisions shall receive all copies of materials transmitted by the applicant to the Department of Energy and Environmental Protection. During the course of the hearing, you heard testimony from the applicant's engineer, I believe, that due to the size of the site and the size of the disturbance, they're subject to state level permitting with DEEP for the that work. So we're going to get copies of that vis-a-vis this condition. And then the last two are standard that come out of your regulations, that the permit shall expire if not exercised within 5 years from the date of issuance, and that a permit is not transferable, assigned, or sublet sold to any other person without the written permission of this agency. It is somewhat infrequent, but not unheard of, that you grant a wetlands permit approval and that property changes hands without the permit being exercised, and the new purchaser of the property wants to exercise the permit, they need to come back to you just to ask for your permission. It appears as a communication item most typically, and you can get a little bit more information to ensure the new purchaser will administer and adhere to the plan. And then the last one is just that this approval, included in conditions, would get striped onto a final plan set that we would record and maintain in the Planning and Zoning Office.
Mr. Kaplan, question?
I have a question for Mr. DeMay. If there's any possibility to add or amend any of these conditions to potentially urge the applicant to consider preserving the large, greater than 30 diameter at breast height oak trees at the southern end of the parcel, and particularly since the southernmost stormwater detention system as a condition is being moved further west, the tree that was at that location. In particular, that tree, since some oaks do have the potential to have commingled root systems, and that tree is not that far from the champion white oak, and given the age and size of those trees, I think that would also be beneficial, not just for the wetland, but for the champion white oak. I don't know if that's a friendly motion amendment for the rest of the commission, but I just wanted to see if there's any possibility that we would be able to add that.
So just procedurally, right now, Mr. Dumais has suggested an amendment, but it hasn't been voted on or accepted or anything like that. So any additions to that are perfectly okay. But I do want to check and make sure that Mr. Dumais and Mr. Pudlick, did you get all that?
I think we took sufficient notes there. You very narrowly focused where you're looking at. I think we can capture that in a condition.
I will also point out, of the half a dozen trees in particular that I referred to, those are the three healthiest by far. I also spent time walking the site as well as reviewing the materials, but I did walk the site several times. And of those 6 trees in particular that are within 100 feet of the wetland that appeared to be slated for removal. Those are the 3 healthiest by far.
And let me just ask a procedural question, Mr. Dumais. Oh, do you get into your specific questions? and
Thank
then I'll
you,
ask
Mr.
a
Chairman.
procedural
Through you to Commissioner Kaplan. Just to be clear, I'm looking at sheet C0.020 overall demolition plan. I just picked this because it identifies trees to be removed. We're talking about this southernmost portion.
Correct.
This tree here was the conflict with the storm, and these were 4 others that I identified. What were the other, all of these?
Nope.
Nope.
It's the ones that you circled,
Yep.
and there's some of the.
So that way you kind of, it provides flexibility, but still closes the loop if there's a conflict where they did try to look at it, and here's why. Is that,
Sure.
okay.
So that would be in addition to the amendment proposed. Okay. So,
And that
yeah,
is something that I did request during the application process. When they did the inventory, I asked for which trees are being removed and why certain ones were, the rationale. So not inconsistent.
All right, so then I think so there are 2, oh, do you have?
Nope, just that
okay.
I was-
So there are 2, I'll call them two proposed amendments, one for Mr. Dumais, one for Mr. Kaplan. As you are the movement, you're the second. Do you accept one or both of those?
I accept both
Okay.
sets of
Ms.
conditions.
Grisilli, so on the record, the movement and the second accepts both. So that is now the motion that is before us. Given that the motion has been amended, then I would, if anyone has anything further to say as to the amended motion, I would say it now before we call the vote. Ms. Gillette.
I just want to thank Mr. Kaplan for your amendment and saving the trees and working your way through all the condition-y part. Thank you. Good.
I didn't even need to look over. I could feel Liz beaming as this discussion was occurring. Okay, so do we have any further comment on the motion as amended? Anything from staff or from council that we need to do or say before we try the minds? All right. And then with that, let me try your minds. All those in favor say aye.
Aye.
Those opposed, abstentions, it passes. Do we have any further business tonight, Mr. Dumais?
Mr. Chairman, we do not.
Okay.
A future meeting reminder, we did list this as February 5th. We remember we talked at our last meeting, or at the last meeting I wasn't there. That meeting was being moved to a special meeting date on February 12th, I believe.
Okay, I was
Just
going
because
to
of
ask that.
conflict, this room is finally getting some technology upgrades to allow us to conduct public hearing
Oh,
presentations.
sorry, I couldn't hear you over the, oh, okay, yes, of course, yeah. All right, thank you.
Getting a whiteboard.
Yeah, whiteboard, sorry, we're going back to chalkboard. Okay, thank you. All right, then, with that, then, do we have a motion to adjourn?
I'll make a motion to adjourn.
Do we have a second?
Second.
All those in favor? Aye. Those opposed?